What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. I got a six-pack of cases for you, so we got a bunch of them. Let's get right to it. First case is out of the 5th DCA, Aluise versus Spanos. This has to do with grandparent visitation rights and also the UCCJEA. So in Florida, it's really difficult for grandparents to get any visitation time-sharing rights. Particularly when the parents object. It has to be something like where one of the parents is, I believe, in jail and the other one is dead, something along those lines. But essentially, it's very difficult. But in other states, like this one is Pennsylvania, it's a lot easier for grandparents to get some sort of visitation rights. And so that's what happened. The grandparents in this case got visitation rights in Pennsylvania, and then the parents moved down here to Florida and essentially domesticated their Pennsylvania child custody order. And so the question was, then the parents later moved to modify the child custody order, probably to eliminate the grandparents' visitation rights. So the question is jurisdictional, and the UCCJEA, is the court here in Florida able to do that? And the answer is yes. And the reason has to do with the fact that the statute talks about the Pennsylvania court loses jurisdiction when the parents and the child move away from the state. Now the question is, do the grandparents count as like a parent or someone acting as a parent? I think that's what they're called. Person acting as a parent is the language that the UCCJA uses. So the grandparents in this case did not qualify as that because they did not really have long-term custody, physical custody of the child. They only had essentially some limited time-sharing rights during the year. They didn't have any actual custody of the child, physical custody of the child, rights to bring the child back up to Pennsylvania. So they did not count. So therefore, because the parents and the child moved down here to Florida, the Pennsylvania court lost its continuing exclusive jurisdiction, and the Florida court here was able to take jurisdiction and modify. Next case is Nos versus Nos. This is out of 3rd DCA. This is a divorce litigation, marital dissolution of marriage. Has to do with appreciation and value of a premarital business. So the wife had a premarital staffing agency business, and of course when they go to the trial, no one is really prepared, it seems like, to value the wife's increase in value of the business. Of course, the husband is trying to argue that the entire business is marital because of the wife's efforts during the marriage. And it seems like the wife was arguing, well, not no, but maybe some of the appreciation and value of the business due to the wife's efforts during the marriage, perhaps that's marital. But nobody had really sufficient information to value that increase in value of the business. So I think it was the wife moved to bifurcate the proceedings. Actually, I think it was the husband. The husband moved to bifurcate the proceedings to get more discovery on the value of the wife's increase in value. At first, the trial court denied that pre-trial, but then later the trial court, I guess, realized, hey, I don't really have anything to value the business. I got to bifurcate this. So the trial court bifurcated that issue. But at the same time, the trial court equitably distributed half of the value of the business's bank accounts, all without even joining the company as a party to the proceedings. Remember, this clear law. You have to join the third-party corporation as a party to the proceedings in order to distribute any of its assets. Otherwise, the court just has lack of personal jurisdiction over that company. So the court abused its discretion by distributing the money in the corporation without having it joined. There's other issues in this case, distribution of personal property, that the husband basically just testified generally to the value of it without getting into the specifics of the jewelry and other personal items and furnishings. He failed to describe the property with sufficient specificity in order to allow the court to value it. So keep that in mind if somebody doesn't bring, the party can testify to the value of their own assets, but it's got to be at least somewhat specific as to what the values of each asset is. The next case is Wilson versus the DOR, and this has to do with a father who wanted to proceed in circuit court, get served with a DOR petition or to basically establish child support. Remember, the DOR can only establish child support. It doesn't deal with time sharing or parenting issues. So if a parent wants to opt out of the DOR administrative proceedings, he can do that in writing, object, and then force the DOR to proceed in circuit court, family court. So what happened here was the father was never actually served with the finalized request by the child support agency. So he got it, I think it was sent to the wrong mailing address. The waiver of service was sent to the wrong mailing address, so that got reversed. So he has to have an opportunity to object and proceed in circuit court if he wanted to. Next case is a mortgage foreclosure slash homestead slash probate kind of case. I found this super interesting. This is one where he did get away with it. So basically, if you're a mortgagor, or I'm sorry, if you're a mortgagee, basically, if you're a lender, you got to make sure that the spouse of the mortgagor signs the mortgage, joining the mortgage and basically waiving their homestead rights. So what happened here was a long time ago, I think it was like the 90s or something. A wife owned a real property outright by herself. I'm sorry, she didn't. She purchased the property in her own name. Husband was not on the deed. She got a mortgage. She got a purchase money mortgage to buy the property. Again, husband was not on the mortgage, and he was alive, I guess, and they were married at the time. For whatever reason, the mortgage company didn't make the husband sign his name on the mortgage. So what happens is many years later, the wife dies. Husband claims homestead rights. He gets the property, and then the mortgage company tries to foreclose. But of course, husband now says, "Hey, I never signed that mortgage. It doesn't apply. It's invalid." So the appellate court said, "You know what? You're probably right. You are right." Because the mortgage was ineffective as it pertains to the husband. He never signed it, he never joined it. So the bank was out of luck, could not foreclose specifically on that mortgage. The bank may have other ways to get around this. There's things like, I think it's called some sort of equitable estoppel or something along those lines. But essentially the lender may be able to get some rights to a lien, but not pursuant to that specific mortgage. That mortgage is invalid, and they cannot foreclose on that mortgage. Next case is the DOR versus Harris. Has to do with paternity testing. Same type of idea. Look, DOR can only deal with child support, specifically a child support hearing officer. So in this case, a child support hearing officer ordered the father to do the parties, I guess, to do a DNA test of the child, and the father do a DNA test. They cannot do that. Not only was the paternity not an issue and there was no sufficient good cause to order the paternity test, the scientific DNA testing, genetic testing, but more specifically, a child support hearing officer lacks jurisdiction to hear any disputed paternity case. If it has to do with whether paternity is disputed or valid, child support hearing officer cannot hear that. So that was error. So if they try to order a genetic test with a child support hearing officer, can't do it. Next case is Marin versus Marin. This is the last case, has to do with contempt and life insurance. So what happened was these guys got divorced, parties got divorced. In order to secure the alimony award, the husband was ordered to get a life insurance policy. It happens all the time. $700,000 was the amount of the death benefit of the life insurance policy. Husband didn't do it. He claimed he was unable to get the life insurance policy, I guess because of his health or for whatever reason. So former wife filed a motion for enforcement and contempt, and as the contempt sanction, the court entered a money judgment in favor of the wife for the full $700,000. That got reversed on appeal. So as a contempt sanction, or essentially a sanction for civil contempt, it cannot be the full amount of the life insurance policy because, number one, that's a contingency, right? That would presume that the former husband, dies before the wife does, which we don't know that that could never happen. So really, the actual damages are not the full death benefit amount, but perhaps the amount of the premiums or something like that. And also, because remember, this is coercive in nature, so we want to compel the former husband to purchase the life insurance policy. So having a money judgment like that is not it's not compensatory, and it's not coercive. So it was an invalid contempt sanction. It was not sufficient, not commensurate with the loss actually suffered by the former wife. So it's not a valid sanction for civil contempt. So other remedies that the trial court could pursue to try to get this guy to obtain a life insurance policy, they had to do it that way. But they couldn't do a full money judgment for the $700,000, the death benefit. All right, guys, that's it for this week. I hope everybody enjoyed it. See you guys next time. See you next week.